Before we get started, I have a quick favor. I've been self-funding the Finding Genius podcast for 5 years now. I've done over 3,000 episodes. And as you can see on YouTube, we're up over 1 million views on the channel, which is fantastic. The next thing I really want to push on is to get up to 10,000 subscribers. Because once we do, we'll be able to put a donate button and we'll be able to solicit donations to help keep the podcast running and to also get the Finding Genius Foundation moving along. We have a big project studying anxiety, depression, and PTSD and working on a product to help people overcome these problems because I've seen them explode recently after the last 2 years of the whole virus situation. So if you would, please subscribe to the podcast. That would help us tremendously. Give us a thumbs up and check in the description for Buy Me a Coffee. It's about $5. If you could buy me a coffee, I'd really appreciate it. It would help keep the channel going, and I love coffee. Thank you.
Forget frequently asked questions.
Common sense, common knowledge, or Google.
How about advice from a real genius? 95% of people in any profession are good enough to be qualified and licensed. 5%
go above and beyond.
They become very good at what they do, but only
0.1%
are real geniuses. Richard Jacobs has made it his life's mission to find them for you. He hunts down and interviews geniuses in every field: sleep science, cancer, stem cells, ketogenic diets, and more. Here come the geniuses. This is the Finding Genius Podcast
with Richard Jacobs.
Hello, this is Richard Jacobs with the Finding Genius Podcast. My guest is attorney Jonathan Brayman. He's a partner at Green Q Law. We're going to talk about vehicle forensics and how both people that are, pulled over by police in a traffic stop or in an accident may unintendedly create evidence that could be for or against their case and their circumstance. So I think it's going to be a very interesting call. Welcome, Jonathan. Thank you for coming.
Thanks very much, Richard. Happy to join you.
Yeah, tell me a bit about your background as an attorney, and then how did you come to focus on this intricate area of the law?
Sure. So, like you said, I'm a attorney in Chicago. My practice is focused on criminal defense, both at the federal and state level, as well as the appellate level, and also civil rights cases. So, I've been an attorney. I'm a partner in the law firm of Breen & Pugh in Chicago. And, I also serve on the board of directors of the National Association of Criminal Defense Lawyers. I've been a lawyer for about 13 years now. And a number of years ago, I was asked to take on experts in a certain homicide case that me and my partners, Tom Breen and Todd Pugh, were trying. And I was tasked with the experts in the case. And one of the experts was a guy from a company called Berla, which is essentially the Celebrite for vehicles. And, Berla is a technology that has been around for about a decade plus, but is not well known even to, a lot of criminal defense practitioners. At the time that we tried the case, it was right before the pandemic. So it was October of 2019. Berla was a company in the Beltway in Maryland that was specializing in doing these dumps of vehicles and, parsing and analyzing the data. And there was, one of their analysts that came out and testified in this homicide case. And it was a homicide case that we don't have the death penalty in Illinois anymore. But if we did, it was the type of case that would have been a death penalty case. It was a homicide. Oh, wow. Yeah, it was a homicide of a 9-year-old. So the state was not sparing any resources in, hiring experts. They flew in a DNA expert from Australia who testified about, a certain type of DNA testing that he had originated called probabilistic genotyping. And they flew in this expert from Maryland who did the parsings of the data from the vehicle that was involved in the homicide. There's other experts too, like there was, a guy from the FBI who testified about cell site location information, but I was tasked with the experts in the case. And so I came to learn about, the Berla technology, the IV tool that they use. And then I found it fascinating. And it was really very much an extension of, computers and digital forensics that have to do with cell phones, where, most criminal practitioners and prosecutors are familiar with Celebrite, the technology that law enforcement uses to extract data from cell phones, and it can be some of the really most damning evidence in cases because it's everything. It's your location, it's your Google, what you're Googling, it's your text messages, and all of that information that is deeply personal, deeply revealing, and can be deeply incriminating if in fact you are the person that is the offender in the case. So,
but one quick question: if you marry the use of cell phones while someone's in a car driving, I would think using GPS and other techniques, you can very clearly say that phone was in that car traveling that route. The person, obviously, someone needs to be operating the vehicle, but as long as you can corroborate that, the two technologies working together, like all the onboard computers for a car and for the cell phone, you get the black box being corroborated, I guess, by the phone and vice versa. I would guess you could have a very highly specific and accurate representation of who was in the car and what was going on, right?
Yeah, absolutely. And, the IV tool that Berla uses, it becomes more and more sophisticated with every iteration and, is more available to more cars. And, nowadays, it used to be that, the infotainment systems were only really in luxury vehicles, and now they're in every vehicle. And so later on, I was tasked with that expert, did a cross-examination. I'd interviewed him and, gone through all these parsings and all this data in a really, kind of a deep dive way, because I always find that, there can be, especially in cell phone extractions, there can be some really, really helpful and really, really harmful things if they are really extensive, detailed extractions. And so, it was really interesting to do that work and to learn about the technology. And then later on, a few years later, serving on the board of the National Association of Criminal Defense Lawyers, his board, and there's a Fourth Amendment Center that NACDL has that is really doing, the work that is at the forefront of technology and the Fourth Amendment around the country. So dealing with geofence warrants and, keyword search warrants and, cell phone extractions and stingrays, all of those issues. And, we had a case maybe a year before that homicide trial that we did that dealt with law enforcement seeking to get into a cell phone that had a passcode, and that we were not just going to volunteer the passcode, to law enforcement. So in litigating what is referred to as kind of compelled decryption of the device, basically either a search warrant or a judge saying, you have to do this or you're going to be held in contempt of court. I learned a lot from Mike Price and Jumana Musa and NACDL's Fourth Amendment Center about cell phones. And, a lot of stuff that I didn't know at all. And that I think a lot of people, they just don't know, even people that are working in the space of, digital evidence in their cases where, most folks think, well, I've got a 4-digit passcode or a 6-digit passcode most of the time because those are the defaults. And so, through that work, I learned that, there's not a great deal of protection when it comes to trying to, brute force into the device. So, I had learned about cell phones through that and had changed, my cell phone passcode to a 12-digit passcode.
Let's make a scenario, and maybe you can tell me, I know you don't have time to prepare, but let's make a scenario. Let's say, I don't know, someone's after me for some reason. I owe them money, and I'm in a car, and they start chasing me in their car, and maybe they shoot at me once or twice, and, I end up getting into an accident, crashing, and then they leave. Let's say that's the scenario.
Yeah.
Both of us have our phones on us. What are some examples of the things that you could compel discovery on and subpoena to help prove my case and help me? Or if you're representing what could you do?
In a civil context?
Oh, let's do both. Let's do criminal first, and then we'll do the civil part. Yeah.
Okay. So saying that maybe you are the suspect that chased, the purported victim vehicle, you have a cell phone, you come in to my office and engage me to represent you in an investigation, which was, kind of the scenario that I was laying out. It was in, the cell phone case dealt with a fatal motor vehicle accident. And, basically a pedestrian that was hit by a vehicle that was suspected to be driven by my client, and that client had a cell phone. Very much like you and your hypothetical have a cell phone, and you are the suspect of law enforcement, that you chased this other vehicle, that there was an accident, and that the victim suffered some physical injury, maybe property injury, and law enforcement is pursuing any and all leads and evidence that they can to clear the case and make a charge of, maybe reckless conduct, reckless discharge, aggravated discharge, attempt murder against you. So, I asked you, Richard, obviously this is, hypothetical attorney-client, communication that we're having in the office in the context of, representation. And I would ask you, Richard, you have a cell phone. Yeah. I don't need to know, and I don't want to know what your passcode is, but how is your device protected? And what would you say in that scenario?
Before we continue, I've been personally funding the Finding Genius podcast for 4.5 years now, which has led to 2,700 plus interviews of clinicians, researchers, scientists, CEOs, and other amazing people who are working to advance science and improve our lives and our world. Even though this podcast gets 100,000 plus downloads a month, we need your help to reach hundreds of thousands more worldwide. Please visit findinggeniuspodcast.com and click on Support Us. We have 3 levels of membership from $10 to $49 a month, including perks such as the ability to see ahead in our interview calendar and ask questions of upcoming guests, transcripts of podcasts you're interested in, the ability to request specific topics or guests, and more. Visit findinggeniuspodcast.com and click Support Us today. Now back to the show.
Yeah, well, I would say either facial recognition, or I use the thumbprint, or I have like a generic four-number passcode.
Okay. So generally, under the law, biometrics are far less protected than passcodes. So either a pattern or a passcode, digital or alphanumeric, biometrics, either a thumbprint or a face, generally has much less protection under both Fourth Amendment, Fifth Amendment case law than just a passcode. And,
does that mean they could compel me, if it's, let's say it's thumbprint, they could compel me more easily to give my thumbprint and then use that to access the phone?
Yes, because, and the case law is varied along, some courts say, no, it's all the same, right? It's, it's all the same, whether it's a face, a thumb, a passcode, it's all the same. It all has the same protection. But, other courts say, no, it's not. A passcode is the contents of that person's mind, and a person revealing the contents of their mind, like a combination to a wall safe, is protected under the Fifth Amendment. And for law enforcement to compel the person to give that information up would be a violation of their Fifth Amendment rights. Not so, these courts would say as to biometrics, that presenting a face or a thumb doesn't cause you to have to reveal the contents of your mind at all. And it's very much like being asked or compelled to stand in a lineup where there's not the same protection. And so generally, the way that I would counsel a client prospectively is get rid of the biometrics on your phone, both because it's less protected when, under law enforcement scrutiny, but it's also, you end up, your thumbprint, your face, it ends up in databases that you don't necessarily, want to be in. And also practically speaking, it's easier for, folks to force their way into the phone. They can just basically wave it in front of your face and unlock the phone, whereas they can't do that with a passcode. Generally with passcodes, you want them to be long and alphanumeric. So most people, I don't have the stats on this, but as a reference point, when I did my set of talks about 1.5 years ago, I asked a room of criminal defense lawyers, people that are working in this space, how many of you have a 4-digit, 6-digit passcode? And, the vast majority of the room, probably 85 to 90%, had a 6-digit passcode because it's the default. And, there was probably in a room of 250 lawyers and technologists, there's a couple technologists. There was like 4 people that, said that they had a 12-digit or more alphanumeric passcode. One of them was my partner. One of them was a guy that, was a technologist at Uprise.
So what would happen if I had either a pattern or a 4-digit passcode and I said, Your Honor, I just don't remember it. The stress of the case is such that I don't remember. I can't tell you even though I want to. So if I had a 12-digit alphanumeric one, I guess I could say, or you would say, as my counsel, Your Honor, no human being can really remember an alphanumeric 12-digit. It has to be written down somewhere, and we cannot find, where this is written down, or someone said,
I couldn't say that to a court in candor because, I have a 17-digit alphanumeric password, and I remember it not because I, have to access, a cheat sheet. It's because it's a certain pattern, right? Because otherwise I wouldn't be able to remember it. But, there's an argument that it would be a violation of your rights to compel you to have to give up that information, that it's protected under the Fifth Amendment. But there's case law that's going against that argument. And, there was a case in the Illinois Supreme Court recently that, the NACDL and the state affiliate, the Illinois Association of Criminal Defense Lawyers, had an amicus with the ACLU and the Electronic Frontier Foundation that supported that very position. And the court supported the Attorney General's position on the applicability of the Fifth Amendment. It was a 6-1 decision. It wasn't even a real close call. But, practically speaking, Richard, if law enforcement has your phone and it's a 4-digit passcode, they don't need to go, with a search warrant, which they have to get now, under Riley versus California, a 2014 Supreme Court case. They have to get a search warrant. They can't just, rifle through the contents of your phone because, the Supreme Court in that case talked about how highly sensitive the information that we have on our cell phones is nowadays. It's not like when you arrest somebody and go through their wallet or billfold, the physical items. So there, this difference between physical and digital. And
also too, what comes to mind is I know there's I don't know if it's a rule or what you call, but things are in plain sight. I get pulled over. Let's say I have a gun on the passenger seat sitting there. The police sees it. They got probable cause now to do whatever. If they have to ask me to open my trunk, and it's locked, I guess I can refuse, and maybe they can compel, maybe they can't. But so my question here is, if they get into a phone, if they crack it and get into it, is everything on the phone now considered, quote unquote, in plain digital sight and accessible, or can they only go to certain apps? Do they have to get separate warrants for separate aspects of the phone, like text versus app usage versus geolocation data, et cetera?
Yeah, that's a really good, interesting question that has a few different issues baked in there. So you're talking about plain view. Generally, you need a search warrant for people's, property, person, vehicle, papers. And so, if, police pull you over, you're lawfully, stopped and detained, there's a gun on the front seat, that's in plain view. And that is an exception to the warrant requirement in the Fourth Amendment. When we talk about digital evidence, though, it's different, right? So, there's this contrast between an old case called Robinson that said that it's perfectly fine that incident to somebody's arrest, that you go through their wallet and inspect photographs and, different papers. That's fine. But when we're talking about cell phones and computers like infotainment systems, I would argue that, that's an extension of Riley and cell phones, that you need a warrant, absolutely need a warrant. And so, in that context, law enforcement has to get a warrant. And so then after they are into the phone, what they can look at is that deals with the command of the warrant and how it's written. Practically speaking, there are warrants that I see in state court that I believe are general warrants, which have been prohibited, since the founding, but that say very much, will detail the investigation and then say, the person had a cell phone on them at the time they were arrested. And so we should be able to basically look at everything on the phone. My position, and you talked about this app by app, and because Cellebrite can differentiate the different data, when it does its extraction and search, my position always is that it needs to be tailored. The scope of the warrant needs to be tailored to the probable cause showing within the complaint for the search warrant in the first place. You can't just say, well, we suspect this person committed a crime, and so now we want to go through his cell phone, go through his infotainment system without any nexus and no showing in terms of, tailoring what you're searching to the probable cause showing in the first place. So in terms of, plain view, that is an exception to the warrant requirement, but the Supreme Court has been explicit that when it comes to digital information and, cell phones, and I would argue infotainment systems, that law enforcement absolutely has to get a warrant in that context. So, but that might be different, right? So they got to get a warrant for the phone. But what about...
Let me give you a quick example. Like if, let's say I have a bank with Wells Fargo and I have the Wells Fargo app, to access my banking. And then I have Gmail and I have a Gmail app. The police get into the phone. Can they compel me to give the passcode for the Wells Fargo app? Or is that a whole separate thing? And then for the email, if there's a password on there. So for a given app, if there's a separate password on it, does that give you any more protection or no? Or if you could just access an app with no passcode, once you're on the phone, like what would be the difference in the eyes of the law?
No, my position would be that, additional passwords that are required to unlock information within the cell phone, that would be a violation of your Fifth Amendment rights to compel you to give up that information. But going back to plain view, if you have if your settings are such on your iPhone or your Android that your Wells Fargo notifications are going off, or your text messages are going off, and you can read them on the notification screen, and law enforcement, lawfully has possession of the phone, can they read the communications that are clearly displayed in plain view on the face screen of your iPhone? That's a very different question. I think the answer is, yeah, they can. It's in plain view. And, it's not like they're not violating your rights by putting the phone in front of your face to unlock it to circumvent the warrant requirement. I mean, they have the phone sitting there while you're in the interrogation room and it's going off, and there's messages from, somebody with a certain name that's, is a suspected accomplice of yours that's saying, that is giving inculpatory information. I think that's fair game under plain view, because they're not, they're not going into the phone. There's a whole, there'd be an argument about whether the cell phone is lawfully in their custody, especially if, you're not in custody at the time and you're a witness, and they seize your phone without authority or legal process. But I think that's kind of when plain view would come up. And then, but no, in terms of, having apps that have additional passcodes, I think that gives you, a whole nother layer of protection under the Fifth Amendment. But going back to something we were talking about before in terms of the difference between 4 digits, 12, 17-digit alphanumeric passcodes, law enforcement may not need to go to a judge to compel you to give up that information as a suspect, pre-charging with a search warrant, if they can just crack the phone anyways. That's sort of what judges sometimes say.
Oh, that's why. Okay.
Yeah, why do they need to ask me to compel him, to provide this information? Otherwise, you could be held in contempt, be jailed if you don't, to purge the, contempt, if they have the technology to crack the phone. Well, that's sort of a nuanced question, because if they have your cell phone, they have Richard's cell phone that's got a 4-digit passcode, and they have my cell phone that's got a 17-digit alphanumeric password, and they hook your phone and my phone up to Gray Key and try to, break into it because they have the authority of a search warrant to do so, they'll get into your phone within half an hour at most. They may get into my cell phone, maybe. It used to be a 12-digit or more passcode. It would take them 100 years to get into my phone. I think the technology evolves all the time, and so, but a really long alphanumeric passcode like the one that I have on my cell phone, I don't have biometrics, and I've got this long alphanumeric passcode. I don't think, I don't think they'll be able to get into my phone. So then they have to make additional request of, hey, judge, can you please, issue an order compelling this person to provide the credentials to get into the phone because we have a search warrant, or else it's another step that law enforcement would need to take, in that case, when we litigate.
But at least that gives you a chance to narrow the scope of, of the warrant in that case. In the other case, if they just crack it, then you're just reacting. But if this is the case and they have to have the judge hear it, you could be there and say, Your Honor, I want to limit the scope to text messages only or whatever it may be.
Yeah, absolutely. And, a lot of prosecutors would say, well, what do you mean there's no case? You don't have a remedy at this point to be able to file, a motion or a petition to quash the search warrant. But, that process is very much available to suspects. And we were able, the judge allowed us to do it on that case from 2019, the fatal accident case. And actually, we briefed it, and the law was different back then in Illinois. And the judge said, he read everything. He gave Corporation Counsel of the Village time to respond, which they were thoroughly, kind of miffed about what to do in this scenario. And the judge said, ultimately said, yeah, I got it. I read everything. I think they're right. I didn't have jurisdiction to enter the order in the first place. I'm going to quash my own, compulsion order. And so, the compulsion order gets quashed. They have a search warrant. They can't get into the phone. So by the time the case goes to trial, there was no, they had never cracked the phone. They had it at the, digital lab, but I never got any additional discovery on that. And then ultimately, the client, and I did not think a righteous prosecution, he was acquitted at trial, and he should have been. There was no evidence that what he did was reckless or anything. It was, the scenario was a guy walking out into traffic, while it was raining, dark at night, in dark clothing, and my client didn't do anything wrong. I actually tried to help, called 911, and it was just overzealous law enforcement in that scenario trying to make a charge against him when he was very much, a tragic figure, just like the decedent and the decedent's wife. I mean, it was a terribly sad case, but it was one that taught me a lot about, the kind of different legal processes that prosecutors and law enforcement can use and how to react to them, but also be proactive when it comes to, not creating additional evidence.
Can a phone be used as a honeypot? Like, let's say they take my phone and I don't know, they suspect I have two accomplices, and can they call those people on my phone or text them and try to get them to reveal damaging information, or is that illegal to do so?
That's a very interesting question. I mean, I think there's a concept in the law about that the police do not have to be honest in their conduct. They can't go in front of a grand jury and lie or, go into court and perjure themselves. But, can they, in an interrogation room, can they mislead you about what evidence they have? Can they mislead you about, an alleged accomplice who's in the other interrogation room down the hall is maybe saying they can? There's law that says they can. Can they use your property to try to compel somebody else to make, incriminating statements? It doesn't seem like that would be lawful. And, good defenders would say that was a violation of, the client's constitutional rights, that, that's the client's property, that, that law enforcement is using that without authority, without permission or consent or legal authority to use that cell phone to communicate to another person, purporting to be the client. Yeah. I mean, I would have an objection to that, but there is sort of this concept that law enforcement does not always need to be honest when they're investigating criminal cases. So that's a complicated legal question, but good defenders would certainly say, no, law enforcement cannot use my client's property to communicate with other people, purporting to be my client. That's a violation of his rights. The other person, if they took the bait and said something, whether honest or not, would also say, that was unauthorized by law enforcement to do that.
So would it be a protection? I mean, this is probably paranoia, but if I'm driving my car and I lock my cell phone in the glove box or the trunk, So if I'm pulled over, they can't really access it. It would probably never happen. If someone's that paranoid, obviously they're probably up to something no good. But I'm just curious about that scenario.
So what's the scenario that you're laying out, that your cell phone is locked in a glove box or?
Yeah, I'm driving my car and I worry if I get pulled over, they may try to take my phone for whatever reason. So I put it in the glove box and I lock it. So the cell phone's not on my person. It's not in plain sight. Let's say law enforcement asked for it, but I'm like, well, I don't have it. It's locked in the trunk or it's locked in the glove box. What happens then?
Well, if you're arrested in that scenario, whether law enforcement can inventory the contents of the vehicle, under an impound inventory, that would be an exception to the warrant requirement if it was justified and it was according to the police department's, procedures. But yeah, I mean, if you get arrested and your car isn't coming with you, your wife's there and she can take the vehicle, she has got a driver's license, it's not a situation where they need to take the vehicle, that would give you some additional protection. But I think, the biggest thing is just that baseline of, not having some protection on the device because, really our cell phones, they have so much information about us. You can pretty much determine nowadays with younger folks and most people that use cell phones the way that most people do. I mean, you can learn a whole lot of information about a person by going through a fulsome extraction of their cell phone. Everywhere they've been, the apps that they're using, who their spouse is, in the context of like my cell phone. Yeah, it's got all kinds of case matter material on there, privileged communications, conversations, emails with my partners and opposing counsel. And, there's just so much. If you pull down every one of your emails, every one of your text messages, your location information,
right,
medical history, I mean, it's a window into your soul, in the words of, our Supreme Court and Riley. And so, the baseline protection is don't have biometrics on your phone because it's easy to get into a phone with biometrics. Practically, but also kind of legally, there's less protection. And then having a long alphanumeric passcode. And you don't need to have one that's 20 digits that you won't remember. But if you can, do a pattern that you'll remember, which I do, then that gives you a lot of protection, whether it be from, law enforcement scrutiny, but also just, somebody steals your phone and be able to get in there. I mean, I feel like I would feel much more secure that some stranger isn't rifling through my information and, some pretty sensitive client material and case material having a really, a longer passcode because, it's really easy to get around these things, especially if they're just these, basic 4-digit passcode.
Well, very good, Jonathan. Time, but if you're open to it, I'd like to have you back for a round 2. We discussed a lot of cell phone stuff. That's where I took it. But the vehicle infotainment system, I think, is a whole nother area. But for now, I appreciate you coming on the podcast. And, for those that want to speak to you about expert witnesses you might have access to, what's a good way for listeners to contact you if they're interested?
So my email is jbrayman, so JBRAYMAN @BreenPughLaw. It's BREENPUGHLAW.com. And I'd be happy to talk to you more about the vehicle component of it, because that's a really underdeveloped area technologically, but also in the law, and it's distinct from cell phones where, you and I have talked about, how to protect them. And, our cell phones, our computers, we think of, they're encrypted, you have passcodes on them. And, as far as I know, there's not a single vehicle manufacturer that allows you to protect the data that is on vehicles. So on the, on the computers that are on vehicles, which, can very much pull down the whole contents of your cell phone onto that infotainment system. And so, part of their talk and, why I guess people got really up in arms and activated by the idea that a rental car could have all your text messages and, all this highly sensitive data was, this clip from the founder of Berla was on this podcast talking about, like, laughing about, like, yeah, you get a rental car, you plug in and they ask you whether you want to, sync your contacts.
Right.
Everybody says no. Nobody's going to opt into that system. But with no permission, no consent, that rental car is pulling down all your text messages onto this rental car. And, it was like, I think that was really alarming to folks. And, seeing some of the comments on there, which my wife got a real kick out of when I was like, yeah, looks like, apparently this thing is, gone kind of viral. My wife was going through the comments kind of laughing, but people thought like that it was like conspiracy theorist talk, and it's like no, yeah. And then there's other people that are like, oh yeah, I worked at a rental car place for 5 years, and absolutely that's the truth, and we always reflash the system, and but it's wild that that's the way that those things are set up, especially nowadays,
Well, very good. Again, thank you for coming. I really appreciate your time and your information. We'll have you back very shortly.
Okay, sounds good. I'll talk to you soon, Richard.
If you like this podcast, please click the link in the description to subscribe and review us on iTunes.
You've been listening to the Finding Genius podcast with Richard Jacobs. If you like what you hear, be sure to review and subscribe to the Finding Genius podcast on iTunes or wherever you listen to podcasts. And want to be smarter than everybody else? Become a premium member at findinggeniuspodcast.com. This podcast is for information only. No advice of any kind is being given. Any action you take or don't take as a result of listening is your sole responsibility. Consult professionals when advice is needed.